Hello, everyone. I'm Steve Atkins in the DC office of McGuireWoods. We appreciate your joining us today. And I'm joined here today with my colleagues, Tyler Van Houten, who is in our Houston office, and Erica Sowers, who is in our Raleigh office. We have done quite a few ITC cases together, and we welcome the opportunity to talk to you about why these strange proceedings are not mere litigation. I'm sure I've been told this several times, so whether you can interrupt us with questions. So if you can, please do so. If not, there'll be plenty of time at the end to ask us questions. I think these things are much more meaningful if you raise questions and let this be more of a discussion than three folks lecturing to you about something that is a bit strange. So let us begin if we can. If we can have the second slide, please. This is a quote from a former attorney advisor to a judge who's now a judge. This is Judge Shaw at the ITC. And this quote is, "A Section 337 investigation is not mere litigation among private parties." And today we'd like to give you a sense of why it's not mere litigation among private parties. And if I may, I'll just give you a couple of examples at the start. What if you were told that you could go to a place and sue people and not tell them, and the ones you did tell, you identify the closest product they have to your patent, but you don't mention the other products they have until you've won at the ITC, then you go to customs and you make it much broader than perhaps people thought it was. Those are two of the reasons this is such a strange proceeding, and two of the reasons there are companies around the world who say, when I'm sued in federal district court in the United States or in the similar courts in other countries, I engage in some discovery, I dangle them around, or maybe let them pursue me a bit, and then eventually I may write them a check or we go to trial, but usually I write them a check and we're done. But it's not a high priority. When we are sued at the ITC, it is all hands on deck, because we're about to be shut out of the biggest market, or one of the biggest markets in the world. We take these very seriously, and in our opinion, and companies have actually told me this, several large companies, that at the ITC, patents are much more valuable. So today we'd like to talk to you a bit about that. First, we'll talk about the ITC, this Section 337, which is a hybrid of a trade and intellectual property statute. We'll talk a bit about the remedies, the process, some statistics, and I promise there are not many statistics. Redesigns, which if there is a silver bullet to get out of these cases, it's a redesign. And then we'll mention some upcoming sessions we plan to have concerning best practices. So if we could please have the next slide. Okay. And this is slide 3, I believe. So first of all, the players at the ITC. There's the staff, there are administrative law judges, there's the general counsel's office, and the commissioners. Commissioners are appointed by the President of the United States. They serve various terms, staggered terms. But the first person at the ITC you'll encounter is the staff. Most cases have staff lawyers assigned, some do not. But the staff represents the public interest. The staff will take positions on experts. They will question experts at depositions. They put in briefs. The staff can be your best friend or one of your worst enemies. And if you know what you're doing at the ITC, you will want your lawyers to meet with the staff privately. Nothing dodgy or unethical about that. It is perfectly appropriate. It helps the staff. And it helps you, of course, helps your client's interests. We have had meetings with the staff where they came into the room and said, I've looked at your marketing materials, and your marketing materials look very similar to this patent. And I've said to this one staff person, just give us an hour. As hard as it's going to be, we lawyers are going to shut up, and you can just talk to our expert. The staff lawyer gave us about 4 hours that afternoon, and after speaking with our expert, left the office thinking we did not infringe after he had thought that we did infringe at the beginning. In fact, the staff had written his pretrial brief indicating to the judge that in the staff's opinion, we infringed. He went back and changed that, so when we saw the brief, it made a difference. He had changed his opinion and changed his arguments. The staff is a crucial player at the ITC. The next person is the administrative law judges. There are several judges at the ITC, most of whom have great experience at the ITC. There are a couple of younger ones, and even by now they have great experience because we're so busy at the ITC. These judges, unlike federal district judges who do guns and drugs one day or one morning and then they're doing patents in the afternoon, these judges do nothing but IP. They do patents or trademarks or trade secrets, mask works, but by far, even today, it's patents. 95, 96% of these cases are patent cases. And these judges do these cases day in, day out. They run the case, they deal with discovery disputes. Actually, they do whatever they can to avoid having to deal with them, but they will resolve the discovery disputes. They will hold what we call a bench trial where they will receive evidence. They will then write a decision, which is invariably too long, could be several hundred pages. That then goes up to the commissioners for review. And the general counsel's office is the office at the ITC responsible for this review. They write the decisions, they consult with the commissioners. Your ultimate audience at the ITC is this general counsel's office. When we do these cases at the ITC, one of the first things we do is figure out who this general counsel lawyer is. We then go and get decisions written by that general counsel person over the years, assuming they've been there for some years. We want to cite those decisions. People like hearing themselves talk, especially when they think they're right. So we cite to those decisions, and that's your ultimate audience. The commissioners are involved in many different aspects of the ITC's wheelhouse, from trade disputes to subsidies, so they have a lot on their plate. The general counsel's office advises them with respect to the 337 investigations. Okay, if I may now, I'll turn it over to my colleague Tyler Van Houten in our Houston office, please.
Thanks, Steve, and welcome to everyone. One of the things that the ITC does is conduct these what are called Section 337 investigations. And I was going to read something from a previous paper that I did on the ITC that I thought was a good definition of what the ITC is. The ITC is a federal agency with the authority, among other trade-related matters, to adjudicate cases involving companies that domestically exploit U.S. IP rights and those who import allegedly infringing products under Section 337 of the Tariff Act of 1930. So that's basically what the ITC is. It's a trade agency. It has many trade-related aspects that it governs, but one of which is the Section 337 investigations. To qualify for one of these Section 337 investigations, the plaintiff, or what's called the complainant in the ITC, has to meet some criteria. And the ultimate goal, if you're the complainant, is to exclude from the United States what are products or processes that are violating an IP right in the U.S. So the criteria that you have to basically meet, there has to be a U.S. industry using a valid IP right, and this is referred to in ITC cases as the domestic industry requirement. We'll talk about that in a little bit. You also have to have products that are imported or will be imported into the U.S. This importation is another requirement. So if you have a product that is allegedly infringing a patent that's manufactured domestically and sold domestically, the ITC would not have jurisdiction over that product. It has to be a product that's imported into the United States. And finally, the product has to infringe a valid U.S. IP right. The majority of those, the majority of the ITC cases involve patents, but they do have the jurisdiction to hear cases involving trademark infringement, trade dress, trade secrets, parallel imports or gray market goods. And if you're not familiar with those, they're essentially black market goods are not authentic goods. They're counterfeit. Gray market goods are those goods that are actually legitimate goods manufactured by a company outside the United States for a lower price, sold outside the United States for generally a lower price. And the issue is when then somebody buys those products who's not authorized by the manufacturer, imports them back into the United States, and sells them in competition with the domestic goods, and they can sell them for a lower price. So that's one of the other IP rights that the ITC can govern. So that's basically the basic criteria. We'll expand on this, and I'll turn it back over to Steve and Eric.
So let's talk now about remedies if we can. These are the types of orders that the Commission enters. They really issue three different types of orders. Two are customs orders enforced by customs, and one is enforced by the ITC itself. So the first one is this limited exclusion order, and this is from a case that we did several years ago. By the way, in the top right-hand corner, you see it says 551, 337 TA 551. These investigations are all assigned numbers. We're now up to about, I think, 1,250 or so. Some unsuspecting complainant recently filed a complaint at the ITC with, I think they had 12 patents. They thought they were going to have one tidy investigation with one respondent, one company they've sued. The Commission had other ideas, so when they started the investigation, they broke it into three. So someone who was going to do one ITC case is now doing three ITC cases. In any event, these numbers are assigned to the investigations, and we often refer to these as the 551, for example. So this is a case we did on laser barcode scanners. And this is the order that we got from the Commission after the trial and after the Commission review. So it says here to Customs, you're to seize the products of respondents' Metrologic Instruments of Blackwood, New Jersey, and Metrologics of Suzhou, China, of barcode scanners. There's no model number here. There's no specificity. It says if they infringe these claims, you're to seize them. So what one might do at the ITC is what I mentioned earlier. Find the product of your competitor that is closest to your patents. Try the case just on that product. Then you get to Customs with this limited exclusion order, and you say, the two companies named here, Metrologic and Metro Technologies, seize all of their whole line of barcode scanners because they infringe. And another wrinkle here is before the ITC, when we're fighting at the ITC, the patent holder has to prove that you infringe. They have to map their patent claim onto your products. After these orders issue, you must prove, if you are the importer, you must prove that you do not infringe. So the world really goes upside down. It's a dramatic difference. So importation is a privilege. You want to import, you must convince Customs and perhaps the ITC that you do not infringe. So this is a limited exclusion order, pretty run-of-the-mill. We know who brought the case. We know the companies that are affected. No other company who's going to bring in barcode scanners is going to care much about this. They may watch it with some interest, but they're not going to be blocked. Let's talk about the next order, please. If we could have the next slide. This is the order that should concern you. Under this order, all that Customs is told, and this was on plastic food containers, the 514 investigation, is seize plastic food containers. And I can't remember how many people were sued here. We didn't work on this case, but assume 5 companies were named in the ITC complaint. But assume 30 companies are shipping plastic food containers into the US. So you've sued people and you've not told them. So after this order issues, you go to Customs and say, these folks weren't identified in any of the papers. They didn't participate in the case. We did the trial. They infringe. Stop their products. And if they try to convince you that they don't infringe and you should let them in, they have that burden. So that is one of the remarkable things about the ITC, that you can sue people and not tell them. But there are side effects to this as well. I have a very good friend in China who is a very astute businessman in northern China. I didn't know this man from Adam when a friend in Shanghai asked me if I would go up to meet with him. And I was on the way up to Beijing So I said, sure, I'll go meet this guy. And he said, look, I've told him he's made a mistake, but he knows I can barely spell ITC. So I'm not quite sure what that agency is, but why don't you go talk to him, because I think he's making a huge mistake. So I go up, and we're in this beautiful conference room with wood that's probably illegally harvested from Africa that's very precious and expensive, and we're drinking this beautiful tea, and he's very kind and very nice. And he says I asked him how his business was, and he said, it's booming. He said, I've hired 250 employees. I've built new dorms for them to live in on the campus of my company. And I said, why is your business booming? And he said, well, it's that ITC thing in your hometown, Washington. It's a great place. And I said, you know, most Chinese companies would disagree with you on that. How has it helped you? He said, well, this company has sued at the ITC, and they've named 32 of my competitors. So pretty soon, as I understand it, customs in the US is going to stop my competitors' products. So all of their customers have started coming to me. In fact, I've spent probably $2 million leasing new land from the Chinese government, building these dorms, hiring employees. This is a good thing. So I explained to him, after I made sure that I had a clear exit from the room, that he had been sued too, because they were seeking a general order, and they were almost certainly going to get one. So he threw me out, but he first said that there's no way that could happen. Maybe in China you could sue someone and not tell them, but you could never do that in America. It would violate the American dream. A couple of days later, he called me in Beijing, and we had tea and a different meal. And he asked if we could help. We could not help. We had a conflict, so we couldn't help. But he was able to navigate his way around that. But I think most people are very surprised that you can go to the ITC and sue someone and not tell them. If you are ever interested in suing at the ITC, this is exactly the type of order you should get. Because why do whack-a-mole, for example? Why beat these people down over and over again when you can get one of these and your fight is at customs? And the burdens are different. You no longer have to show they infringe your IP. They have to show people that they do not in order to be able to import. So these are incredibly powerful tools. These are the main reason that the Chinese government in Beijing has a division that does nothing but focus on 337 investigations. Because it's one thing to sue people in federal district court and get a bunch of money, or get a judgment for a bunch of money, if they don't have any money in the United States. And if they have any money or assets in the United States, you may be the last person to know where that is. But with these, you're grabbing them where it counts. You're grabbing their products, and you're keeping them out of the market. So Beijing has a division that helps companies fight these cases. Okay, let's now talk about the next order. If we could have the next slide. This is a cease and desist order. So what happens to goods after they've been imported when they're cleared customs and they're in the United States? These relate to inventory. They require that you no longer can market, and this is the one that we got for against the companies in the laser barcode scanners, the 551. So they were banned from importing more products, from selling, marketing, advertising, distributing. You can't do anything with these products except ship them back out. You can ship them out of the country, but you may not continue to sell them. So about 10 years ago, we were invited to go to Taiwan because a company had lost one of these cases. And of course, their first knee-jerk reaction was to fire the lawyers who had lost the case. The only lawyers who don't lose cases are the ones who don't try enough of them. But anyway, these folks had lost. But part of the advice these folks had given them, unfortunately, was ship a bunch of product in because you're about to come out with a new product that's going to replace these, and it's very different from these patents, even more different than the current product. Rent warehouses in the US and ship all these products to the US and just sell, because once you get past customs, the ITC can't touch you. Apparently, they didn't quite know about these cease and desist orders. So we're sitting in this conference room near Taipei, and the boss's assistant is there, and she is, I think she's like senior vice president. She really runs the company. And she said to me, we've got all these warehouses, got all this product. And I said, well, you have this cease and desist order, so you'll want to ship that back out. She said, you foreign devil lawyers are not very good business people, do you know what we pay to ship these goods in and pay? We have leases on these warehouses. We're going to keep selling this because ITC can't really can't touch us. It's beyond customs. So I said, well, we won't be able to help you with that. And I don't think you're going to want to do that. And I'll give you some reasons, but let me give you the primary reason. There is no money penalty for violating a customs order. Either of those exclusion orders, you get caught, customs sends the product back or directs you to send it back. But there's no monetary penalty. But with a cease and desist order, the penalty is per day, the greater of 2 times the value of the goods or $100,000 a day. So this person went down the hall and talked to the boss, the founder of the company, and she came back and she said, boss wants to know 100,000 Taiwan dollar or US dollar. So I explained to her that it was US dollar, and she said, okay, we'll ship the products back out. If you're ever suing at the ITC, you want one of these orders. These orders have all sorts of strategic benefits, not just the $100,000 a day, redesigns, which Erica will talk about in a bit, and how they're a bit of a silver bullet. These orders can chill redesigns because of the risks that come with these orders. These are critical orders to get, and in some ways, these are more valuable than exclusion orders. And the next slide, I think we just mentioned the penalty, so I think we could skip that. Next, Tyler, back to you. No, the process.
So there are a number of differences between an ITC investigation and a district court litigation involving allegations of patent infringement. And I'll just touch on a few of them here. There's obviously a lot of information on this slide. The first is sort of the parties to an ITC investigation. In a regular district court litigation, you have the plaintiffs and the defendants. One says infringement, one says no infringement. In an ITC, you have a complainant, which is the equivalent of a plaintiff. You have respondent, which is the equivalent of the defendant. And you have the staff, or the OUII, the Office of Office of
Unfair Import Investigations.
Unfair Import Investigations. Right. I always say the staff, so that's why I always get it wrong. But they're effectively another litigant, and so you have a three-way litigation, and the staff can take its own positions. It can join the position of either the complainant or the respondent. So it's a very unique dynamic there if you've only done district court litigation to go from a two-party litigation to effectively a three-party litigation. The judge in an ITC investigation, as Steve mentioned, is the administrative law judge, or the ALJ, equivalent essentially to what you're going to see in a district court litigation, although they're not Article III judges. The jurisdiction, as Steve mentioned, is in rem jurisdiction, which is jurisdiction over the product and not necessarily the respondent. So it doesn't matter that the respondent has no company in the United States, it's not domiciled anywhere, that doesn't matter. The jurisdiction for the ITC is over the products. And of course, in district court, you have to have personal jurisdiction over the defendants, and you have to have subject matter jurisdiction, which for a patent case, what that means is you just can't bring a patent case in state court, it has to be in federal court. Counterclaims, this is another difference. They're available in the ITC, but you have to effectively bring them in another venue. You can't bring counterclaims, for example, if you get sued in the ITC and you want to countersue on your own patents against the complainant, you can't do that in the investigation where you're being sued. You have to either remove that to district court litigation or file a new ITC investigation. And of course, counterclaims like that are available in district court. Applicable rules, there's the Commission Rules of Practice and Procedure in an ITC investigation, and more importantly, the ALJ's ground rules. Those are really going to govern the case. And then in the district court, you have the Federal Rules of Civil Procedure, the local rules, and you may have some standing orders from the respective judge. Domestic industry, we talked about this at the outset. Complainants must demonstrate domestic exploitation of the asserted patents or patents. What that means is whatever they're relying on to show that their domestic industry case in the United States, their patent or whatever IP right they're trying to enforce has to cover those products. There's no such requirement in the district court litigation. So if you're a respondent in the ITC, you essentially have two opportunities to show no infringement. You have the opportunity to show that you don't infringe your products that are accused don't infringe, and you also have the opportunity to show that complainants' products that they're relying on for the domestic industry don't fall under the scope of the claims that are being asserted. Here's another big one. Typical time to respond to discovery, it's only 10 days in the ITC. And in many investigations, it's dependent on the ALJ. There are no limitations on discovery, meaning there can be 100 interrogatories served and you have to respond in 10 days. There can be 1,000 RFPs served and you have to respond in 10 days. Not so in the district court. There are limitations by the federal rules and generally by specific courts, and the response time is generally 30 days. Same for motions. Time to respond in the ITC is 10 days, sometimes fewer. In the district court, it depends on the venue, but generally about 2 weeks. Another important distinction between the ITC and district court is the claim interpretation or Markman hearing. Generally in the ITC, it's dependent on the ALJ and it's dependent on other factors, but you will have a Markman proceeding, but you may not get a Markman decision from the ALJ and the ITC until the ALJ renders his or her opinion, which is effectively the ruling of the case. What that means is that your expert and the other side's expert will have to opine potentially on two different claim constructions. And then you will have to go to the evidentiary hearing, which is the equivalent of a trial, and argue two potentially different, sometimes totally distinct claim constructions as to why you don't infringe under one and why you don't infringe under the other sides, and same with validity. It's not very efficient, and I think, again, it's one of the issues I have with the ITC is that there's not a requirement that there be a Markman hearing and order prior to expert reports in the evidentiary hearing. I've never had a district court litigation where we didn't have that. So, I mean, you could have a situation where it doesn't happen, but it's extremely unlikely, and I don't think it's ever really done. The evidentiary trial or hearing, it's held before the ALJ, and the district court held before the judge or a jury, depending. Typical time frame to resolution, this is another big distinction. In the ITC, by statute, it's 15 to 18 months. In the district court, it depends on the venue. It could be 2 to 3 years, could be longer. In venues where there are a lot more patent cases, for example, the Western District of Texas now, Judge Albright's trying to get to trial in about 18 months. The remedies are different. As Steve mentioned, exclusion order and cease and desist order in the ITC. Damages are available in the district court. There are no damages available at the ITC, only the exclusion order and the cease and desist order. You can get a permanent injunction in district court, which is sort of like an exclusion order, but the bar is very high. The trial decision, an ID by an ALJ, that's what's referred to as initial determination. It's essentially the bench ruling from the ALJ that will be reviewed by the commission. The commission will either approve it, modify it, or reject it. In the district court, you get a jury verdict or a written decision from a judge in a bench trial. Appeals for both venues, the ITC and the district court, is directly to the Federal Circuit. And lastly, a stay pending patent reexamination to the USPTO. In the ITC, that's highly unlikely. The ITC sort of has a disdain for the PTAB for some reason or another, and they don't like to give the PTAB much discretion. So if you have an instituted IPR while the ITC investigation is ongoing, the ALJ and the commission really don't care. They're not going to stop their investigation. In the district court, it depends on the venue, but you can get a stay. In the Western District of Texas, which is now the busiest venue for patent cases, Judge Albright to my knowledge, has not yet stayed a case based on an IPR institution. He likes to say that he can get to trial faster than the IPR can be resolved. So it just depends on the district court. But I ran through those quickly, but those are some of the big differences between the ITC and the district court.
Thank you, Charlie. Erica?
Hi, everyone. I wanted to take you guys through just a few numbers. So on the next slide, we've compiled some numbers on the types of unfair acts being alleged in the ITC investigations. You can see from 2014 to 2020. And as you can see, among patent infringement, trademark infringement, and trade secret misappropriation, the ITC is clearly the most popular for patent disputes. And Steve touched on that earlier. And then you can also see in the last two columns on this slide, the ITC does handle a handful of investigations concerning multiple types of unfair acts. But again, the most popular is going to be the patent disputes. Now on the next slide, regarding patent infringement at the ITC, we have separated out some various technology areas of the accused products. And you can see over time, computer and telecommunications products do remain the most popular area, followed by pharmaceuticals and medical devices. So as you can see, the ITC is very familiar with complex technology. And in that regard, it really is a unique forum because us attorneys and even the ALJs, we have to know international trade law, the ITC rules, customs rules, but then we also have to have a strong background in IP. And many of us attorneys have scientific or technical backgrounds. The last category on this slide is other, and that's pretty much a catch-all for anything not captured above. And one investigation that came to mind when I was looking at this was not too long ago, the ITC handled kind of like the intergalactic patent wars for baby carriers, like, you know, the actual carriers that a person can carry their baby. And so they had Lilla Baby and Ergo Baby and Baby Bjorn. So truly the ITC sees it all. Now I'd like to switch gears, if we can go to the next slide, and talk about redesigns. Steve mentioned this earlier as the silver bullet. So in the next slide, we've given 3 different options to handle redesigns. And the reason we want to talk about redesigns is because respondents frequently come up with a new model or a redesigned product during or after the investigation. So the first option to address the redesign is before the ALJ in the original proceeding. Now, of course, this would require a respondent to actually come up with the redesign, manufacture the redesign, import it into the country, all while this very quick investigation is going on. So it's not always an option, but if it is, we do encourage our clients to consider it. It does have some advantages. First, at that point, it is the complainant's burden, the patent holder's burden, to show that the redesign infringes. And then also, if you already have an expert in the case, that expert can provide some support for the non-infringement. In addition, the ALJ and the ITC will already have some familiarity with this technical area and with the products at issue. And also, it will allow you to take advantage of that quick timeline of the investigation to really get a ruling on your redesign and kind of be on your way. But if that's not an option, we list 2 other options. The second one is a Rule 177 request. This is a request made to customs after an ITC issues an exclusion order, which Steve talked about earlier. So under this option, if the complainant prevails in the investigation, a respondent can still request a ruling from customs that its redesigned product falls outside the scope of that exclusion order, and therefore it can come into the country. But unlike the first option, now it's going to be your burden to prove non-infringement. And that decision at customs would be appealable to the United States Court of International Trade. Now, the third option that we list is an advisory proceeding. And this is an advisory opinion that you would seek from the ITC to determine whether that redesigned product would violate the exclusion order. This is almost like a mini ITC investigation, so it may require discovery, a hearing. Again, it's going to be your burden at this point. And advisory opinions are not appealable. But depending on when the redesign is completed and you know, what you want to do, those are 3 solid options for dealing with redesigns. So with that, I will send it back to Steve and Tyler, and I think we can open it up for questions.
Thank you, Erica. Yes, if anyone has questions, I skipped over the process phase just to save some time. But if you have questions about that, we're happy to answer those, or anything else, of course. No questions. Maybe we can go to the next slide and just talk about upcoming sessions. We will hope on April 28th to hold a best practices for respondent or defendant at the ITC. So if you're sued, we'll offer some tips for best practices. And we hope to have some in-house counsel join the panel for that. And then on June 9th, later this year, we'll have best practices for complainants. So if you're going to bring a case, here are the things we go through the tips for best practices there. So we hope you can join us for those. We appreciate your joining us today. I hope it was useful and informative. And thank you again very much for joining us.